you for joining us today. I'm Shauna Fleischbein with Castle Group Property Management. If you're not familiar with us, we are a property management company that specializes in generally large-scale HOAs and condominium buildings. Communities that have, amenities and generally staff on site. And we are located throughout the state of Florida, but we have our local offices here in Tampa. We have a Lakewood Ranch office, as well as a Estero office, and Orlando, which I think is most of the viewers on today. And then we have offices throughout North Florida and the Southeast area as well. And today I'm joined by Keith Skorowitz of Appleton Reese. He's going to be our expert of the day. So I'm going to hand it over to you, Keith.
Thank you, Shauna. Good morning, everyone. I know everybody's excited to talk a little bit about condominium cooperative association inspections and reserves here at 11 o'clock on a beautiful Tuesday morning here in the summertime. We're going to try to take this from a big picture standpoint. As Shauna mentioned, I used to say that the ink is barely dry on this statute, but I don't even think that all of the ones and zeros transmitting this legislation have been fully complete. So we're going to try to go through this. There are, and I will highlight them as we go through this. We're going to have 5 course objectives. Number 5, if you're taking notes, is really going to be dependent on each different association. You'll hear me say this if some of you have been through these with me before. Every association is like a snowflake. Again, I just back up a little bit. My name is Keith Skorowitz. I've been practicing in the area of condominium and homeowner association law for almost 20 years here in the state. It's my practice. I'm happy to try to answer as many questions as I possibly can, but some of them will be what we call document specific. So if I can't answer them, if you want to check with me offline, we can do that. I did see that someone posted in the chat if we're going to be answering the questions that were submitted. I'm going to try, and Shauna and I are going to try to get through as many of those questions that were submitted. If we didn't, feel free to stick them in the chat and we will go ahead and try to get to them. So it's hard for me to tell from the roster of folks on the call, but the statute we're going to be talking about today was a recent one from the legislative session that was packed up right next to, you may have read in the news, packed up right next to the Disney legislation that you may have heard about. So they really covered a lot of ground in that last special session. We're going to kind of break things down here. So the most important thing to remember is that we're going to be talking about Chapter 718 and how the new legislation affects condominium associations in the state of Florida with respect to reserves and inspections and engineering as of the effective date of the new law and the processes that you need to put in place. For those of you who are on the call who are homeowners associations and you're just looking to learn about this, note that this statute does not apply to Chapter 720 homeowners associations, but it will affect you if you are in an association that has needs for engineering or reserve studies or inspecting any of your assets, because the demand for engineers and labor in this area, in this field, is good, if not already, is going to go through the roof. So will affect your plan. So we're going to start with how did things exist before Surfside? It gives us kind of a baseline. You can change that slide, Shauna. Kind of a baseline of where we need to be when we started this before Surfside. So the question is, what were the associations obligated to inspect and to do with regard to reserves before Surfside? Next slide. So the most important thing to remember here is that, and I'm going to cover this, we're going to draw a little line back to this bullet point later, but under point 1, under 718.111, you've probably heard this, the officers and directors have a fiduciary, of the association have a fiduciary duty to the owners. There's been some changes in the law with respect to the fiduciary relationship. There are now per se violations, which didn't exist before, which will certainly on a go-forward basis affect your insurance. We're going to cover a little bit more about that later. If you don't take anything else away from today, I'll highlight this section, but 718.111 is a good section to print out. Someone did ask in the questions before about, is there an easy way for board members to look up the statutes short of calling an attorney or subscribing to LexisNexis? The answer is yes. The Florida Senate website has a free copy online of the entire Florida Code. So you can look that up at no cost to you. You can keep these sites. We'll provide a copy of this presentation, and you can go and read these sites. The primary sections we're going to be dealing with today are 111 and 112. You'll hear me refer to that a couple of different times. So you've got the fiduciary relationship, the power to collect assessments to repair and replace the common elements. You have to you make sure compliance with the Florida Fire Prevention Code, and there'll be more about that in a minute. And the right to access the units to repair or replace the common elements. That's kind of the broad powers of the association before. So we'll talk about the changes. Next slide.
Keith, I know you're probably going to get into this anyway, but we did have somebody ask, I know this is a question a lot of people are asking, do the recent law changes for condo reserves apply to all condo associations or just those that are over three floors or higher?
So we're going to break that down a little bit further because there are two types. There's two documents that they have required. There are what are called Milestone Inspections, MIs, and there are Structural Integrity Reserve Reports that are required. So that if we can dig into that a little bit right now. Let me pull up my notes here. Give me a second. This isn't important. The definition of the SIRS, which is the Structural Integrity Reserve Study, is not limited to structures 3 stories in height or higher. So it's our opinion that everyone's got to do that. There are, you heard me mention at the outset, there are some glitches in the law. And we're going to get to the waiver of reserves issue, which to me and some of the colleagues and my colleagues that practice in this area, there are some built-in ambiguities about whether or not you still have the power to reserve in a building that's only 1 or 2 stories. So if that ambiguity, Shauna, and you couple that with this increased scrutiny and potential per se breach of fiduciary duty clause, I tend to be, you and I know, we've talked about this, I tend to be pretty conservative. I'm loath to tell a client that has a 1 or 2 story building that they can waive reserves on a go forward basis, at least as it is at this point. Our hope is that the legislature comes up with a fix, but that's not how it sits right now. So if you have a condo or if you have a condo that's got 1 and 2 story buildings, or it's 3 stories and greater, you really should get with your lawyer, you should get with your insurance folks, and you should do that sooner rather than later so that you can begin to plan, which we'll talk about those plans in a little bit in terms of how to move forward. So this is important. This slide is pre-Surfside. So when I say pre-Surfside, I'm referring to the terrible collapse and then the after effect of the legislature requiring what needs to be done on a go-forward basis. So previously, as your management company has probably told you, if you're a condominium, the replacement cost must be determined at least once every 36 months. The association and the board needs to be able to have adequate property insurance, regardless of any requirement to declaration for full insurable value. Replacement costs are similarly and must be based on a replacement cost of the property. That would have to have been done every 36 months. Okay, so that is what typically in the past, Shauna, sometimes I think our clients kind of intertwine the two things with reserve studies and replacement costs, but a reserve study can cover the replacement cost. It's certainly one of those documents, but you need to know what you own and how much it costs to replace it. So, Shauna, I don't know if you want to jump in here, but that's certainly something you should be getting with your management company on and making sure that you've got that scheduled.
Yeah, absolutely. And, we work with our clients too, to then incorporate that into their budgets during budget planning every year to make sure that you're budgeting appropriately in your reserves for all those items. And as you know, Keith, like the whole reserve study and how to do it and what to do could be a whole webinar in itself.
So Tom Kendall, excellent question. Tom Kendall just asked, we're a 2-year-old condo going through a reserve study with an engineering firm. Is there a difference between a reserve study and a structural integrity reserve study? And the answer is yes. So the reserve study required the replacement cost, which is here in 718-111. And we're going to talk about the new reserve study that they added. I'm not saying that all of that material can't be addressed with one scope of engagement with an engineering firm, but they are 2 studies for right now. Again, This statute is about 6 or 8 weeks old. Nobody's done it yet. The engineers are still figuring it out. The lawyers are still figuring it out. The insurance company is still figuring out. But the difference is, generally speaking, Tom, they address different issues. So the reserve study said you have to understand the insurable value and replacement costs of your assets. The structural integrity reserve study, and we're jumping ahead, but since you asked the question, actually addresses a specific list of items, and we'll cover this, but it helps to go over it now. Roofs, load-bearing walls, floors, foundations, fire protection systems, plumbing, electrical, and the catch-all, anything else that negatively affects those items. So that's just really going to be a term of art. Most engineering firms I know will err on the side of saying, hey, listen, if you've got these issues. And again, Tom, no two condos are the same. We have some that look and act like single family homes. They're 2 stories. They look like townhouses, but they're actually condominiums. And then you've got beachfront towers. Then you have mid-rises. You have some have shared walls, some don't. So each, at the risk of repeating myself, each one is like a snowflake. They're all different. So next slide.
We also had Kim submit a question. She said annual insurance study versus reserve funding study for budget purposes are confusing.
I don't know if you want to address that, Shauna, because you deal with that on a daily basis as you head into budget season.
Yeah, so it is confusing, Kim. Like I said, we could probably have a webinar on all of that in itself, and I think we actually do have one scheduled with experts in that area, with insurance and engineers, and I think a little bit later this summer. So I'll be sure when I send out the emails following this to include that in there, because I like to stay in my lane and I don't ever want to give you information that's not accurate. So I'd rather let the insurance agents and the engineers talk on that.
Kim, generally speaking, the reserve study captures the need to provide the information that the board is required to obtain for the 36-month ongoing repeating replacement value. It's typically included in that. If you pulled one from your association, it's probably got a clause in there that says this we're doing this under this statute for this section. A reserve study is a term of art that's used in the industry, but more than likely it captures the needs and requirements of the statute for the insurance replacement cost. So, Robert, I'm just going to try to get through some of these. It looks like we just covered this, the duty to recover. So why don't we skip this slide because the questions are really generated going on a go for it. Okay, so here we are in post-Surfside. Robert, I'll kind of get to this in a second because we're going to talk about the 2 new documents that are required. Next slide. Great questions though, folks. This is really good. So here you go. Here are the 2 types of inspections that apply now. So you have this milestone inspection that has to be done, and there are different timings for when that has to be done, depending on how old your building is and how close to the water you are, generally speaking. The milestone inspection, and I'm not going to bore you with the internals of it because I think that the timing is perhaps more important. If you've got questions about the details of what that involves, we can go ahead and dig in. But I do want to let you know that by December 31st of the year that your building is 30 years old, you must have the milestone inspection done. If you are within 3 miles of the coast, it must be done within the 25th year by December 31st of the 25th year. So that could also be a little bit fluid, and if you've got certificates of occupancy that maybe were amended or they go back in time, you've got to get with your lawyer and you've got to kind of dig into some of the historical documents that apply to your association. I realize, folks, I truly do realize that we are unpacking a lot today. It's a testament to you guys caring about your associations that you're here. And so we're going to try to answer everybody's questions. So Robert had a question. How will engineers structurally evaluate a 4-story building that is totally encased in EFIS with no underground parking? So Sean and I were talking about this, and this will lead into the structural integrity reserve study. What I would ask everybody to do is kind of close their eyes for a moment and forget that the Surfside collapse even happened. Take that out of your frame of reference, because that's only a small part of what drove the legislature to go down this road. They are doing this to check all of the items I just said. So whether it's 4 stories, whether it's 10 stories, whether it's encased in concrete or not, whether you have a parking garage or not, that's not what they're interested in. They are interested in what an engineer says, whether the building is structurally sound or not, whether it's wood frame, whether it's concrete, whether it's a mix of the two. They are interested in doing that. How they go about doing that, that's up to the engineers. That's not a legal issue. That's really going to be probably with things like ground penetrating radar and whatever they use, they may have to do. And we'll get into this. There's phase 1 and phase 2 of the milestone inspections, depending on whether or not an association failed the first one. So there may be some destructive testing. So someone asked earlier, what is the structural integrative reserve study? And it means that it's a study of the reserve funds required for future major repairs and the replacement of the common areas based on visual inspection of the common area. Someone's got to go out there and actually look at it. But this structural integrity reserve study is, you've got to remember, it's a reserve study. They're going to tell you something like those caissons are failing because you're too close to the water. I'm just using Surfside as an example. And you're going to need $1.4 million to replace each one of those caissons. So you're going to need $30 million in 6 years to replace that. The SIRS, the Structural Integrity Reserve Study, is going to tell the association to be able to plan for its expenses. It'll give you the data in terms of what are your assets and what kind of condition are they in, but it will also tell you what are you going to need to spend on a go-forward basis. Next slide. So we covered this a little bit. When must the milestone inspections be completed? The milestones for buildings that are 3 stories in height or greater, that must be done by December 31st after the building reaches 30 years or 25 years after the first occupancy if it's within 3 miles of the coastline. This is of note to those of you who are on the call who are in older buildings, that the CO was issued before July 1, 92, which means it's at least 30 years old. You have to have an initial inspection performed before December 31st, 2024. I'm sorry that I don't have the data right in front of me. But there's something like 16,000 buildings that follow, and maybe even greater. Don't quote me on that. I'd have to look that up, that are greater than this, that fall into this category. That has to be done by December 31st, 2024. So you're really looking at 18 months. It's June of 2022. Shauna's shaking her head because she's probably had calls from clients already trying to schedule these things. So again, for those of you who are on the call who are HOAs and you have amenities laden operations, you really want to get on top of getting in front of, and we could talk about some of the practical aspects of this, but don't just look to reserve studies. Rely on your manager. There's lots of good quality engineering firms in Florida that can help, that will probably have to jump into the fray to provide. Robert, I'll answer your question in a second. That's a great question too. Next slide.
Yeah, so in other words, don't wait till the last minute to try to schedule everything, because these engineers are going to be in high demand. So the phase 1 requires a visual inspection of the building by a licensed architect or engineer. Really what that is we don't know, but it's basically a 60,000 foot view of your assets to see what necessary repairs or maintenance. And they must inspect all areas, inhabitable or inhabitable. So that's probably meaning things like roof lines, crawl spaces, all those different types of areas you may not have been in your buildings. Again, each building's like a snowflake. They're all different. Next slide. So assuming that in a worst case scenario, you don't pass your phase 1 inspection of the milestone inspection, this may involve, someone asked, how do you get into the look inside? It may involve destructive or non-destructive testing, depending on what the inspector says is required. This is really going to be flushed out in terms of what needs to be done. You're going to be working with your
with your experts and your engineers and your architects on a go-forward basis. They will make recommendations as to what they think needs to be done, how they think the repairs could go, what does it affect? Because you have to remember, as I mentioned earlier, although it's in a different part of the statute, the SERS requirement says anything that negatively affects the roof, load walls, and those other items that I mentioned. So the engineers are going to be looking with an eye towards ending up at that milestone inspection. Tom asked a question. It seems that a full reserve study will include a lot more items than just the list for the new SERS now required. Can these two become one study with the SERS? And probably, Tom, yes. But the full reserve study before didn't require a specific investigation of all what I'll call the supporting mechanisms of the building. They didn't specifically require looking at load-bearing walls or floors or foundations. It was typically, and you have to look at the scope of your engagement. And this is where your lawyer and your manager come into play. The scope of the contract that you have with your engineering firm will matter much more on a go-forward basis, because the old reserve study typically looked at things like the life of your pool chairs or the life of the lining of your pool or the paint on your clubhouse. They weren't looking at foundations, electrical, waterproofing, roofing, load-bearing walls. So that is added in, Tom. So yes, they'll probably end up in one work product, but that's yet to be flushed out by how the reserve study folks and the engineers and when the lawyers and the property managers all get together and say, hey, how do we build a report that complies?
Keith, I actually have a question from my experience dealing with managing high-rise condos and reserve studies. In the past it was a little different, but now going forward with all of these laws in place, I have seen boards get reserve studies and they look at them and they say, no, we can get longer out of that. No, we're going to change that. No, we're going to change this. What are the ramifications of that if they don't actually follow the reserve study?
So let's go to the next slide. And the old, so these are, I'm going to cover that in a second because I've got a slide on because there's now local government oversight and there's increased scrutiny by DBPR on other parts of the operations of an association. So this is going to be a little bit kind of threading a needle in terms of, because, Shauna, some folks, to your point, some folks don't get the reserve study. They go out and get a roofer to give them a quote, or they'll go out and get a pool refinisher. They're not required to get a reserve study. You're required to understand what you need to save for in terms of roof painting and paving and any item over $10,000. So we're going to cover that a little bit more, but the consequences now are if you don't save, there's per se fiduciary duty breaches, and you're going to end up in litigation. You're going to end up with substantially increased D&O coverage if you have claims against your directors and officers policy for breach of fiduciary duty, and they've got to defend. So, Robert, another good question: is the inspection form standardized, or is it up to each firm to be thorough? There is no form, and it is not standardized. It is going to be an engineer is a professional who has a license. He's going to have to look at your building. So a lot of you are probably in Orlando. So, you've got mid-rises, you've got towers in downtown. If you come over here on the Gulf Coast, you've got 40-year-old two-story condos on the Intracoastal Waterway. So there's all different types, Robert. There are no forms. So will the state follow up to assure that noted concerns are addressed in a timely fashion? I think that the answer is yes, but it's not going to be just the state. It's going to be also, you'll see this in one of the slides coming up. Man, we are just moving here. That there's local oversight. I am seeing in my practice, I'm seeing increased scrutiny of the DBPR on operations of associations to provide official records or to have the insurance to 36 months, and they're viewing that as an ongoing requirement. For everyone you don't have, it's a violation, and they'll fine the association. So there is substantial increased enforcement by the DBPR, which is what has power over condominiums in Florida.
Yeah, and we've also seen, and I'm sure many of you on this call, if you've spoken to your insurance agent, insurance companies, even before these laws were passed, a month or so ago, insurance agencies are already starting to require things as well. So
I meant to say that at the outset. So there is, if you take away anything from this, Tom, with the great questions, if you take away anything, there is going to be a substantial increased cost to your operations in terms of protecting the structural integrity of your building. And it is not a place to cut corners, because there will be increased scrutiny going forward. This slide has to do with how do we let owners know. Many of you know, there's an official records. The milestone inspection reports are part of the official records of the summary of the association. And there's a requirement that the milestone inspection report be transmitted to all of the owners by mail or email if they have consented. So, and it's also got to be placed on the website if there is a website. Next slide. I'm sorry, let me just move this out of the way here, Shauna. There we go. So to tie back to Tom's question earlier, what government oversight is there in the milestone inspection process? So the law authorized the Board of County Commissioners to establish timeframes and other regulations, presumably through an ordinance structure. Local building departments will also be involved, fire marshals who are also involved, because there's some legislation that's going to kick in terms of fire protection and life safety systems in the building in the next couple of years as well. How these organizations will interface with one another and the association is yet to be seen. And anybody who tells you otherwise, it's just not there yet, because nobody's done it yet. Mm-hmm. But I fully expect that the Board of County Commissioners, nobody wants to end up with another Surfside. So if you think of this like a pendulum, it's swung all the way to almost no enforcement, leaving it up to boards. It's probably going to swing all the way back the other way. There's going to be substantial oversight in the next couple of years to make sure that you've got a couple of different things in terms of your operations. Typically when you get communications from the state or the Board of County Commissioners, you need to make sure that you're right. This sounds simple, but it gives me an opportunity to talk about some of this stuff. Make sure that you get with your manager and that you've got your registered agent updated. Make sure it's accurate. Make sure it's not someone's home. If you have trouble getting a registered agent, talk to your manager, talk to your lawyer, talk to your accountant, have them explain what that is, because that is where the county commissioners in the state and the BVPR will send all of those official communications. Mm-hmm. So typically, this sounds like such a little thing. Sean and I were talking about this, but how you interface with them will mostly be through snail mail, because the DVPR and much of Tallahassee is still in the age of the rotary dial phone. Now we do have, Sunbiz is excellent, but certain things don't get done unless they are through the mail. So
Castle's best practice is to actually have your attorney as your registered agent. That's our recommendation.
Right, and I think that's a good one, because we can see it all come in and we can say what the next step needs to be. Next slide.
Yeah. And Robert had another, I need to just get Robert on a webinar. He's got all the great questions. If a component fails that was not noted in inspection, is the engineering firm liable?
Yes, so that's a great question. I don't have an answer to that. That's definitely going to go towards the engineering firm. So it's important that you have, Robert, an educated board that knows your buildings and says, hey, we used to have an elevator here, but we shuttered it. Is that something we need to inspect? And again, I'm going to be telling clients to err on the side of inspect. Get your understanding. So, listen, there's all the plaintiffs' lawyers who practice in the construction defect area have all kinds of interesting ways to come up with to try to find negligence. But that's a great question. Unfortunately, it's going to be fact specific in terms of the building and the engineer.
Yeah, and so, you just brought up a great point too. You mentioned, somebody knows there used to be an elevator there. There's not an elevator there, anymore. And as I know, we're seeing in a lot of areas, especially you get down into the Sarasota area, we're seeing a lot of turnover in the buildings of, condos are getting passed down and whatever it is. So a lot of that historical knowledge goes away. And so it is so important to document. Like if there's changes like that, make sure it's documented in a place that's not going to just get buried in your record somewhere in a banker's box,
Right.
and is kept so that, your manager or your new incoming board or whatever is aware of those kind of major, alterations that may have been done over the years in these older buildings that nobody may know about anymore.
That's right, Shauna. And if any of you on the call are so inclined and you get bored and you want to look at size 10 font on the internet, a great place to start is in Chapter 718. You can Google it. It's free. There's a list of what are called official records of the association, and they are different for condos versus homeowners associations. That's kind of a good place to start, to go through with your manager or your lawyer and say, hey, do we have all this stuff? You should have it. Things like building plans, plats, all of the things. That's a really good place to kind of start as a checklist of what documents you should have, so that when you interview with your engineer going forward, you make sure you've got that. So good point. So we're going to talk a little bit about the reserve calculations and funding. Next slide. So if you don't take anything away from today, circle this right here, 718-103, subsection 25. It's a definition, I think Tom asked earlier, for structural integrity reserve study. So the comprehensive requirements for reserve studies, complete funding and reserves and restrictions will be effective by 2024. So we are still working through that as practitioners in this area to make sure that we can get everybody in compliance. But somebody had asked earlier about the overlap or integration of the structural integrity reserve study and the full reserve study. So the structural integrity reserve study is examination of the funds. Remember, I mentioned this earlier. It's the funds required for the future repairs of those items, and we'll talk about that list in a second. Must be based on a visual inspection by a licensed architect or engineer for each building that's at least 3 stories in height. Must be completed at least every 10 years. And for existing condominiums, must be completed by December 31st, 2024.
Oops, sorry.
Oops, it's all right. So here's the list, folks. This is the list I've been mentioning over and over. I won't belabor the point. You can see that it's much more thorough than the old reserve study to kind of draw that comparison to the previous question. But I think the takeaway here, folks, is that last item. Someone asked, what if somebody missed something? The statute kind of has built in a catch-all to say that anything that negatively affects the items above. So they're certainly going to be looking at, one of the things that they're going to be looking at, so for example, is the flashing and the watertight envelope of a building, particularly around windows. So if you've got windows, typically windows, I'm not an engineer, but windows are typically built into the structure of a building. They do provide support. So if windows are failing, that's obviously something that negatively affects. So they're going to be looking at a wide variety of the construction of your common elements. We've got, and this is something else to kind of note for going forward. It's not on the slide, but I mentioned it earlier in that the board has the power to enter units to inspect and protect the common elements. This is something you kind of want to keep in the back of your mind, board members on the call, because you're probably going to have to coordinate. You're going to have an initial interview with your engineer to get a plan. You may end up inside of people's units to look at certain types of infrastructure that may be behind the walls, depending on the type of building or structure your condominium is. And that's going to be something you're going to have to get with your lawyer. You're going to have to get access and have a plan in place with your lawyer and your management company to kind of get inside. So there are lots of practical considerations, folks, to consider as we start this process. Next slide.
Don't ever let anybody go into a unit by themselves. That's just asking for trouble.
So Scott Kubler, I hope I said that right, asked a question. He said, technically, our building does not need a milestone inspection until 2034. Should we go ahead and get this done now? 2034 is a little bit away. I don't know that you need to do that right now, but that's certainly something I would think about getting, at least starting to budget for. This isn't going to be cheap. So that's going to be up to you and your board and your expert. You know, if that's something you decide you want to do to get it done sooner, it doesn't hurt, right? You have the information now. I saw Gary posted a question. This is a really good question. This goes to kind of what I was saying earlier. Gary said, most windows are listed in the documents as responsibility of the homeowner. So how will they change this new reserve? Gary, that's not necessarily the case. It depends on the documents. Some documents say the windows, they may be owned, but they're not common elements. They are required to be maintained by the owners. And then you're going to get into an issue of who did the maintenance? When did they last do the maintenance? Who's responsible to inspect that maintenance? Who's checking the caulking? Who's checking the ceiling? So it's not necessarily always the homeowner responsibility. And again, you're living in a shared environment with a shared common structure. So let me kind of take this to its extreme. Let's say the windows in your documents are the responsibility of the association. As a lawyer, I say, well, what does that mean? What part of the window? Just the frame? Just the glass? What does that mean? At the end of the day, it behooves everyone to have a watertight building, because you certainly don't, if it's on the third floor, you don't want water going down to the first and second floor, because you're going to have problems with the other common elements. So there's ways to, and I talk about this, and I think in the next slide, there's ways to deal with, and this is a really important point, another point and takeaway. That question leads to the fact that you may want to consider amending your documents regarding these maintenance responsibilities to put them on the association, so the association can budget for it, use economies of scale, hire the right engineers, and look at your building holistically. Because you don't want an owner fixing a window one way and then the guy down the hall fixes it another way and there's no oversight. That's not a consistent way to keep your building safe. And I don't want to speak for the engineers, but again, certainly something I would consult with the experts on in terms of how do you do that. But if you've got, and a lot of documents do, folks, a lot of documents have ambiguities built in. Now is the time to deal with them if you're going to amend regarding those maintenance responsibilities. So the answer is no, you should not wait to complete your structural integrity reserve study, because you're going to need to be doing it anyway, because you're going to need to be saving. Next slide. So this is what I was talking about earlier. I mentioned earlier at the beginning, I said circle 718.111. If an association fails to complete the structural integrity reserve study or the milestone inspection report by the required deadline, such failure is breach of an officer's and director's fiduciary duty to the unit owners under 718. That is a per se violation. All you have to do is let the deadline go and you'll get sued. So then everybody will say, well, why didn't you do it? So our advice, as Sean and I were just talking about this, is this needs to be a priority in our opinion. My advice to my associations, that I'm doing this a couple of times a week now, is to start to put together a plan on how to deal with this. Because not only, you'll see in bullet point 2, not only is time of the essence because the local architects and engineers will be in high demand, you're going to need to get this. This looks esoteric to folks when they read it in the Orlando Sentinel or the Herald or the Tampa Bay Times. It looks esoteric, but the boots on the ground costs to those folks, particularly those folks who have ceilings on their income, you need to be able to deal with your owners without, because regardless of who's in those seats, whether that board gets recalled because people are upset, these standards will apply. So prices are going to go up. I just say that. Robert asked another question. Is it Robert or Ribbert? I think it's Robert. What specialty engineering firm will be licensed to perform? So there are licensing requirements for PEs, professional engineers, and architects in the state of Florida. Those are highlighted in the statute. So get with your management company, and you're going to want to try to get engineers that have experience in these areas. Now, I say that because you're not going to use a civil engineer to give you the structural integrity reserve report. They may be a PE, but they deal with dirt, not structure and mechanical engineering. So just something to think about. And you can also use an architect as well. So you may need, if you're up against that deadline, you may need to cast that net wide. But get with your management company, get with your lawyer. We typically have relationships with folks that can help you at least get you going in the right direction to provide that for meetings. I would also encourage you to, I said that there's a lot of practical aspects that we're dealing with this in terms of implementation. So you've got this, you got the passage of the law, then you have implementation and funding, right? So as part of implementing, it's good to have a policy for how you're going to create your board notices on a go-forward basis. If the board's going to be addressing the SIRS or the MI at a board meeting, you certainly want to make sure that you've got those in your meeting minutes or in your board meeting notices if people want to participate. Because the last thing you want is someone saying, hey, why didn't you discuss this? And you say, well, we did. You want to kind of keep that, to my last point, keep that line of communication open with your owners, because this is going to be a little bit of a shock to the system for certain associations. Next slide. That might be, can we, surprised we didn't have this question, Shauna. Can we vote to opt out of those requirements? No, the revisions to the Florida law are mandatory and time sensitive. Any of the reserved amounts that are required in 718.112 cannot be used for any other purposes. So this is really important. This is another really important takeaway. Some associations use their reserve funds. They borrow against their reserve funds to prepay your insurance. Shauna probably sees it, and her staff, they see it all the time. So you need to review your governing documents and amend to facilitate borrowing funds if you are using your reserve funds to pay your insurance premiums, because those may not be allowed on a go-forward basis. Let me just hold on one second, Sean. I saw some questions come in. Yeah. So our board is limited to 15% to raise the amount for condo fees year over year. Will this be able to be exceeded given all the new requirements? That's a great question, Joanne. They did, and we think it's a glitch in the statute because they didn't address that, right? So let's say I'm just giving round numbers here. Let's say your operating budget's $1 million, but it needs to be 1.5 next year. There may be requirements in your documents that allow you to go further than that, depending on what your bylaws and declaration says. But that's going to be, the short answer is that was not addressed in the statute, in the new statute. It's going to need to be addressed. But one of the ways you can deal with it first is by looking at your own documents. Robert, there are some reporting requirements. We'll talk about that in a little bit. That's still being flushed out. 12/31/2024, Mr. Alper.
And Keith, George had chatted a little while ago. These have all been updated in the statute at this point, right? As far as if they go searching for them online.
They should be. I have not. It's funny. That's a great question. I haven't looked specifically at the Senate. You have to make sure that when you are in the Senate website looking at the statutes, there's a drop-down box where you can pull down and look at the year. And sometimes they'll add 2022 special session laws. If you don't see this, in the website that you're looking at, contact me. I'll get you guys a PDF of it for easy reading if you don't see it. I don't know how often. Sometimes they don't do it until July. I don't know how often they're doing that.
We also had a question. Does this mean that you cannot have pooled reserve if funds cannot be used for any other purpose?
No, well, you can use them. You can still have pooled reserves, but the any other purpose means you can't borrow against them. So against them for things like insurance. Now, the issue with pooled and other purpose are two, you're conflating two different issues. The pooled reserves just means you're keeping it in a big pile, but broken down inside of that are the items that make up that pool.
Yeah.
So get with the most important thing is to get with your manager to understand what type of reserves that you have and how do you want to do it. Mm-hmm. I am, as a practical matter, I've been telling clients for a couple of years that some of these changes may have been on the horizon. and pooled reserves probably has a short lifespan. I don't know that they address, you got to remember, folks, they did this in a special session because there was such an uproar that it wasn't addressed at the initial legislative session. So again, probably another glitch, but Sean, I don't know what you're hearing, but I suspect pooled reserves are going to go the way of the dodo bird. They will be extinct fairly shortly.
Yeah. I haven't heard any rumblings yet, but it'll be interesting to see what happens for sure. And that's always a question anyway. What's better, pooled or straight lined? And the answer is generally it depends. It depends on the association. It depends on the board. There's a lot of factors and which one's
right.
better anyway.
Tom, they did just enough to get boards moving in the direction of understanding the condition of their buildings. That's the best way I know how to say it. Are there unanswered questions? Sure. But we've got, as your experts, as your lawyers and your engineers and your experienced CAMs, we have to find a way to navigate it. And I make conservative calls with respect to the operation of, I tend to make sure that I'm doing everything possible to comply with all of the different nuances of the law, whether that be records inspection or violations or collections. I try to make sure that my clients are protected so that they're not getting sued. Yes, there are unanswered questions. And no, there's no possible way we can understand the impact of a law like this that includes lots of terms of art and undefined terms. But I will tell you, I am confident that we will be able to find a way through this to get everybody to comply. Florida has some of the most well-developed and mature condominium association lawyers in the country. Outside of maybe California and Texas, our law is so well established. We have such a great bar. We have really well-established management companies. We have lots of engineering options. So, I am positive. Yes, there's ambiguity built in, but I am positive we will find a way forward. Are these requirements being established for Florida condominiums post-Surfside in line with other states that the coastal build-out have imposed, or is Florida breaking new ground? I don't know the answer to that, Joel. I don't practice in other states. Again, this is the pendulum, right? So if you think of the pendulum was all the way over here, basically it's up to the board, do what you want to do. You've read about what happened to the Surfside board. They had these meetings. They needed an $18 million special assessment. Nobody wanted to do it. I can't afford it. And it's going to swing the other way now. Well, the state's going to say, no, go spend the money, tell us the condition of your building, and go fund it, because they're not going to deal with that going forward.
And I have heard some engineers chat about that right after it all happened, when all the rumbling started with all of this. And, the thing is that Florida has a fairly unique environment compared to pretty much any other part of the country, between the humidity and, we're on the coast and, we're a peninsula, there's a lot of things. So you have buildings in New York City, but it's a completely different environment, a completely different world than like Florida. And even California is completely different, than Florida's environment. So, and that may lead into Joel's second question there about having engage a state attorney. Can it be out of state? And I don't know the answer to that, but my guess is you probably want somebody who's fairly, well-versed again in our environment and how that affects buildings here in Florida.
So Joel, that's a great question. I haven't dug down into the definition of a licensed engineer, whether that definition and that part of the statute, which is a completely separate statute, includes PEs from other states. I just don't know the answer to that. Mm-hmm. That may be an option. Where do management companies fit into the equation of advising board of the required maintenance? That's a great question, Robert. So what we're going to do is you're going to work backwards. You're going to think about, you get with your management company because you want to look at this from, and Sean, I don't want to put words in your mouth, but I think that it helps to look at this, Robert, from a standpoint of the budget. How is this going to affect our budget and assessment? And what do we need? Roman numeral 1, we need to get the inspections done. How much is that going to cost? What do we own? Are we a tower? If you're an established condominium, you have some ideas about what you're spending maintenance on. There's an area of the pool deck that is consistently flooded or failing. I don't know. I'm making that up, but you'll get an idea from that. The management companies will help you find the engineers and manage the project. So if you go and get a phase one and you fail, you're going to need your management companies to get in there and to negotiate with your lawyer a second contract for a phase two, do all the scheduling, get in with the owners, all of the issues that come with owning property. Sorry to be a pest. George, you're not being a pest.
Nope.
I have been reading the bill, though I haven't been able to find a revised section 718. The point I'm trying to do is some work on my own. Is the developer required only to have the studies completed or fund the required reserve study before turnover? George, I will get you a copy of the statute. The developer is not required to do the reserve study. Oftentimes they will do it. There are certain things that they are required to do, but it depends. Now, I know that there are some folks on the call, and I don't know how many HOAs and condos we have on the call, but there are, for those of you living in Orange County, there are certain infrastructure reserve requirements under Orange County ordinances that apply to HOAs. That is in addition to all of this. I can give you a whole nother presentation just on that. So if you're in Orange County and you've got questions, and feel free to reach out. I'll see what I can do. But if you've already turned, George, why don't you email me on the side and we'll see if we can't dig into that.
We had another one come in a while ago. Since insurance is the largest budget item for most associations, what do you think of removing it from the budget and having an insurance assessment in time to pay the bill?
I'll let you jump in here, Shauna, but I don't think most documents will allow you to do that because it's typically defined as a common expense that needs to be included in a pro rata share of per unit owner.
Yeah, that's something that I think, needs to be included in your budget. It keeps it clean. It keeps it consistent every year. I'm not sure, that would almost be like having a special assessment, right, Keith?
Yeah, I mean, and that's what some of my bigger clients have done is they'll special assess for $250,000 and kind of keep that on a rolling basis to avoid going into the reserves so that they have the money for reserves, pay the insurance premiums, and they always have it.
Yeah, but I don't think it's probably a good idea to take out insurance altogether from
no.
There's D&O, there's workers' comp insurance, there's all kinds of things in there. So yeah. Okay.
I don't know where I got so excited. Where are we in the
this is the last slide.
Okay. All right. So you guys have me for a few more minutes. These are great questions. If you've got other questions, you can go ahead and reach out. You can email me. I'll give you my phone number. You can call me. George, you're definitely not being a pest.
And I know Carlton in the very beginning asked a question that wasn't necessarily related to our topic today, but we'll use your legal advice here, Keith.
So Carlton,
yeah,
is interested in whether a 55 and older condo community can prohibit sales to any buyer who is not 55. The answer is no, because the federal law that applies there is an exception to the occupant, not the owner.
So in other words, if somebody younger than 55 can...
So I could buy it. I'm 48 years old. I could go buy in a 55 plus. I just can't live in it.
Live there, yeah. Are the slides going to be available after the webinar? Is it okay, Keith, to share the slides with the email? Okay, so I'm going to just...
you know what I'll do too is...
Go ahead.
Go ahead, Shauna.
Oh, I was just going to remind everybody that I will send out an email following this. It may not be today, guys, because I think there were over 50 people registered. But before the end of the week, I will send out an email that'll have Keith's contact information, which is also on the screen right now. It will have a link to this recording in case somebody couldn't join and you want to share that. And it'll also have the PDF of the slideshow, unless Keith has a different version he wants to send. And then Keith, I think you said you had a PDF of the specific information.
I have a PDF, but I also I'll send you, which might be more helpful, I'll send you our legislative summary, which kind of summarizes this in a page and a half.
Perfect. I think I have that. You sent it to me already earlier.
Yeah.
Yeah.
So feel free to share that.
Okay.
And if anybody has trouble getting to Chapter 718 or current version, let me know, and I'll send you a copy.
Mm-hmm.
And I don't want to take, again, if anybody's got their own counsel or your own board members, feel free to reach out to your lawyer too. We're all in this together. I'm just here to help everybody kind of, raise the issues. So I hope everybody enjoyed.
Scott, thank you. Yes, Keith gave us a lot of great information. So thank you for all the compliments that everybody's sending in right now. And for Keith, thank you for your knowledge and
happy to help.
All the content. And we appreciate having you on with us as always. So I think if everybody's good and there's no more questions, I think we're good. And I will send you guys all the information out via email before the end of the week. So thank you, everybody. Have a great day.
Thank you.
Have a great one.
Thanks, Shauna.
Take care. Bye-bye.
Bye-bye.